On June 23, 2022, right before the end of its term, the United States Supreme Court decided the case New York State Rifle and Pistol Association versus Bruen. Prior to this decision, the state of New York made it a crime to possess a firearm without a license, whether inside or outside a home. An individual who wanted to carry a firearm outside their home could, in theory, have a carry concealed permit, but only if that person could prove, quote, proper cause exists, end quote, for doing so. An applicant could only satisfy the proper cause requirement if he or she demonstrated a special need for self-protection distinguishable from that of the general community. 2 individuals in New York applied for permits, but were denied because although they didn't have any negative criminal or mental health records, the state said that their request to carry a handgun concealed for personal protection did not constitute proper cause. The Supreme Court in Bruen held that the Second Amendment's plain text covers an individual right to carry arms, including guaranteeing an individual right to possess and carry weapons in case of confrontation, and that in order to justify a firearm regulation, the government needed to show that the regulation is consistent with the nation's historical tradition of firearm regulation. So going forward, courts need to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. Now, that said, the court recognized that regulatory issues posed by firearms today are not the same as those that the founders faced in 1791, but the Constitution can and must apply to circumstances beyond those that the founders specifically considered. Courts addressing a regulation can use analogies to long-standing laws forbidding the carrying of firearms in sensitive places, like schools and government buildings, to determine whether modern regulations would pass constitutional muster. But the state of New York can't, let's say, just declare the entire island of Manhattan in New York City as a sensitive place simply because it's crowded and generally protected by the NYPD. The burden shifts to New York to show that firearms restrictions are consistent with the nation's historical tradition of firearm regulation. The court recognized that the constitutional right to bear arms in public for self-defense is not a second-class right, and there are no different body of rules that apply to the Second Amendment compared to other Bill of Rights guarantees. A bit on the logic of this decision. There are lots of people who make a big deal that the Second Amendment starts with what looks like an introduction clause, saying, quote, a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. So there's an argument that the people's right to bear arms is contingent on service in the militia. This logic was rejected by the Supreme Court well prior to this term, and in my view, this makes sense when reading the Constitution because of how the founders wrote at the time that it was drafted. Take the Eighth Amendment, for example. It says, excessive bail shall not be required, comma, nor excessive fines imposed, comma, nor cruel and unusual punishments inflicted. All 3 of these terms are contained in one sentence, but have 3 different means of operating. The Sixth Amendment is similarly just one long sentence and includes at least 6 independent rights, including the right to a speedy and public trial, the right to a trial by an impartial local jury, the right to be informed of criminal charges, to confront witnesses, to compel witnesses to appear in court, and to the assistance of counsel. To be clear with that, the right to compel witnesses is independent from a speedy trial right, even though they're all contained in the same run-on sentence. It's just how they wrote back in 1791. But going back to Bruen, know this. In Arizona, we were already what's known as a constitutional carry state. Besides felons, subjects of orders of protection, or people in sensitive areas defined by law, civilians generally have the right to carry firearms here. And the Supreme Court recognized that restrictions like those in New York are actually relatively rare in the United States. Most states have what's known as shall issue permits. meaning that non-felons that pass background checks and sometimes are required to take gun safety courses are generally allowed to exercise their Second Amendment rights by carrying for self-defense. The Bruen ruling doesn't prohibit shall-issue states from continuing to operate their permitting process. If you have any questions or comments, please leave them down below. As always, I'll ask you to like, subscribe, and turn on notifications because that helps my channel grow. Please share this video with anyone else that you know that might find it helpful, and check out future videos which come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Cerbalic. Thanks for watching and stay safe out there.